Morning, Ms. Berry. Okay, Mr. Berry, we're bringing you out now because your lawyer has asked for me to set you a bond.
Yes, sir.
I don't know. I've got two main concerns. First, most importantly, are you a danger to my public? And number two, equally as important, are you going to go back to the jurisdiction you're wanted from?
Permission to speak?
No.
I'll give you a chance.
Yes, sir.
I know that you're going to tell me that it's gumdrops and rainbows and I get it.
Sir.
But the way that I get to know you is how you look on paper, because that tells me who you are,
Sir.
not what's in here, because a lot of people tell me things and when they walk out the door, they turn into someone completely different.
Sir.
And so that will really tell me who you are.
Sir.
Okay. I will give you the opportunity to speak. I'm going to give her the opportunity to speak as well. I'd like to know, number one, where is he wanted from, what for, and what kind of priors does he have?
Yes, Judge. He's wanted out of Fulton County, Georgia. On the front cover of the Fugitive page, it states that he's wanted for theft of taking, but I did a little bit of digging, and it looks like he's wanted for 4 felonies out of the same transaction. I don't know why they didn't include it on the teletype or running his FBI number to confirm. He's wanted additionally for second-degree felony criminal damage to property and two charges for unlawful person employed by or associated with criminal street gang to conduct and participate in criminal activity through commission of offense. It's a very, very long charge name. But it looks like it was the same offenses that he was originally wanted and he was extradited for back in 2022. I guess he either absconded or violated them again, but it looks to be open cases. And specifically addressing bond is that the state would be opposed for him granting a bond. In the past 10 years alone, not excluding other states and anything past that, he's been arrested 21 times, 12 of them felonies, 2 revocations of paroles, and 3 evadings, 2 felonies and 1 misdemeanor. I believe he's a definition of a flight and safety risk, and due to that fact, we request that the court deny bond.
Your Honor, if I may. So in regards to the telegram, because obviously the state has their duty, I have my duty as defense attorney. All of the other charges that were not on that telegram were dismissed. The case was reduced to theft. This case has been pending since God knows when, because Fulton County is a very slow court. Your Honor, here as I stand with the same client, I stood before you 2 years ago asking for a bond for my client to go back. You granted a bond, Your Honor. And when you granted that bond, my client did what you would want anyone to do, which is turn himself in, appear in court. They gave him another court date. However, no, once he checked himself in, he was able to bond out of Fulton County. Since then, that case has still been pending. He has an attorney in that county as well. However, throughout the times, my client moved. The issue was that there was supposed to be an updated address change to the court. So there was a court date, I believe around August the 12th. And because they did not update his address, the notice was sent to his old address. They immediately issued a warrant. So my client was actually picked up when he came back from work. He didn't even know that he had a warrant. And I understand the state's position that my client does have an extensive history. I was also his parole attorney, which he was successfully discharged from as well. I know Mr. Berry, and I could stand for him before this court. Anybody that I have stood before you has always, I'm not going to take a client that's going to embarrass me or embarrass you. He came, last time you allowed and granted a bond. He did exactly what he's supposed to do. And if you do it this time, he would do that again.
I don't give bonds 2 times in a row. And I counsel people every single time when they come here that if I give you a bond now, it's not going to happen again. It's your responsibility. You've been a fugitive once. We don't let you do it over and over and over. I gave you a bond last time. I can't keep doing it because you're going to keep, it's the same thing's going to keep happening.
It's not, sir. I promise you.
I get it, but it did. And I told you last time,
But
it's not going to happen again.
yes, sir. Can I talk to you, please?
But Your Honor, it was not, so this.
How do I know that?
So I'm telling you this because I'm also an officer of the court and I've done my research, Your Honor. It was not his fault. It was not. It was just a mistake of address. That's the only reason why. I've been checking.
He's supposed to update them of
He
any
did.
changes to the address.
Can you
I
speak
did.
for that
Can I
part?
please talk to you, please?
So what I would do is reach out to Fulton County, let them know, and hopefully they'll pull the warrant. They'll pull the hole. Will they not?
So, Your Honor, I've had history with this county. They're very slow.
Yes.
It's very
Have you done
difficult.
work there?
Huh?
You've done work there?
For other clients.
Really?
Yes. Your Honor, can you just listen? Can you just hear him
Please,
out as to
I'm
why?
happy to hear you. Please.
Your Honor.
So with regarding that you did update your address,
Yes.
typically address that.
Yes. Your Honor, the last time you gave me this bond, you told me to get a job and you told me to change my life. And I did that. I completed CDL school. I work every day.
Wonderful.
They put me on insulin. I take insulin 2 times a day. I can't, the way that they expedite you there, I'll be sick by the time I make it. My flight has already been the process of being booked, like you told me to left.
Can't take a flight.
To turn myself in?
You have a warrant. If you try to get on an airplane, they're going to take you into
They let
custody.
me last time, you let me out. They let me take it. I turned, okay, the address, I updated it, Your Honor. And,
How do I know that?
I mean, I didn't,
Am I supposed to take your word for it?
I was honest with you last time about everything.
And that's why I gave you a bond.
But, yeah.
And I told you though, the last time, it's not going to happen again.
But you said if I messed up, and I did not mess up, Your Honor. I did good, Your Honor. I
Great.
promise you.
But now
You
something,
gave me 10 days to turn myself in. I turned myself in 6 days.
Your Honor, it was really because of the address change. And
Please, Your
So
Honor.
if you're not going to at least believe him, you can hopefully.
it's not a matter of belief or disbelief.
Okay.
It's a matter of that we cannot continue to enable. That's what it is. And if I do this now, who's to say it's not going to happen a third time?
It's not, Your
not,
Honor.
because-
Told me that the
dismissed
first
my
time.
cases.
They
They dismissed 3 of the cases, Your
So
Honor.
from the time of this charge was pending, 3 of those cases were dismissed, Your Honor, and then the other cases were said that. Clearly, the
Yes,
reason
sir.
why it's pending is because they don't have anything, but it's not.
So what? I mean, can't you do a speedy trial? Ask for a speedy trial.
So he has an attorney on that court. It's just the court's very slow and it moves very different.
But
Yes,
what
Your
I,
Honor.
what I can assure you is, it was just a mere mistake, Your Honor. Like,
So I just want to
Please,
step in
John.
real quick because I've had one before where they stated it was a clerical error, and I want to say only one time out of all the other times I approached where it was a genuine clerical error. Once they corrected it in the demanding jurisdiction, is they removed the warrant. I've had that happen before. So if the court wants to roll it over for a day, and if counsel wants to contact Fulton County to figure out if it was truly a clerical error and it was a misunderstanding of where it was to be shipped out for
I
notice.
think what they're saying is that there was a problem where he's saying that he updated the address, but they didn't do it.
Sure, and that's what I mean, is if there was an error, right, with the court in
Can I
Fulton
reach out
County.
to them and see if that's the case?
well,
You can Google it, Your Honor. It was a glitch in Atlanta's.
Let me ask you this, Mr. Berry, how did you update your address?
I called a bond company. That's what they entrusted me to do.
Update it, right?
Well, so I don't really talk for their system, but that's what I mean, is if it's a mistake on the court, right, and not
So
the defendant.
what I would do is get into contact with the bail bond company and say, hey, man, this is what we did. You didn't do it the right way. We're going to, if you don't fix this, there's a bail bond board.
The judge is laying down the law with surgical precision, immediately zeroing in on 2 crucial issues: public safety and flight risk. This isn't just courtroom protocol, it's an attempt to predict future behavior based on past actions. Imagine your own past being put on trial to decide your freedom. Here's the classic tension of a bond hearing: past mistakes versus present promises. The defense insists, he did exactly what you asked last time. While the judge responds, I can't keep taking chances.
Initially all they see is the capias issued on August 15th. They haven't filed a motion yet, but that's my point, is before anything else happens, if counsel does want to correct it for both reasons, for the extradition and for the local deferred, it's probably 2 birds, 1 stone to call Fulton County and figure out what happened with the court there.
Try that.
can we roll it tomorrow?
Yes, absolutely. Of course. I would reach out to the bonding company, say, hey, man, I did this. You guys messed up. Fix this. Otherwise, we can file a complaint. You're telling me you did. If you did, then that's the right thing to do.
Your Honor, I mean, I'm begging you, sir. I'm insulin independent now, and life has changed for me. I know I got in trouble in the past, but you instructed me to do something, and I done it step by step. I changed my life, everything, Your Honor. And all
Barry,
sir,
the entire time I've been here, I've never once given a second bond.
So, Your Honor, if I may, if we do
Sure.
get information, would you be
I will never say no, but I don't know. I mean,
Well, I'd rather take I don't know than no, so.
right. I don't know. I don't know. I never want to say no, because you never know what someone else is going to provide you to show you that really it's not his fault. And if it's not, then you know,
Like I said, I've had it happen before where the manager.
if it's really not his fault, would you
And then-
post?
Please,
No, but please, don't beg.
yes.
Because last time we went in, you don't.
Yeah,
Let's see what they have. Let's go from there.
And I will-
I don't want to commit you to an answer. That's really not fair.
yeah.
So-
And in the spirit of transparency, I do show that he hasn't had any violations since he entered in the deferred because it was concurrent with dismissal of the others.
Yes.
So other than this, there have been no other, but it was September of 2022. But it's just with the sheer amount of history, because it's one of the longest I've seen, is that's my concern. And
Saying he's been doing good.
well, that's what.
He's
So
been doing very good.
Right.
They
So that's what I
requested
mean.
early termination for me, sir.
So that's the thing, it's just
Okay.
please.
So I want information from the court because ultimately, in the end, it's not whether it's not the how they prosecute the case. It's whether he's wanted and whether the KBS is true.
Diligence.
So-
Let me see what you got and let's talk.
Okay, we can,
Never gonna, well, I'm not saying never because I always put my foot in my mouth, but let's see what, and we can regroup. Okay?
Thank you.
All right, Mr. Barry.
See you tomorrow.
Next day. Morning, Mr. Eli.
Good morning.
How are you?
Better, a lot better.
You seem clear-headed. Things are going well now. You know, you've got a clear mind of what's going on. The problem is how long that's going to last. You know, shh. God forbid you dig yourself into such a deep hole that you'll never crawl out of. And then if you end up with a criminal case where there's a dead body, that's exactly what you've done. We will do everything in our power to prevent that from happening, no matter what you're doing. All that needs to happen going forward is you do not get into a car. Whatever you're doing in this life, wherever you need to go, don't get into a car. Do you understand? The worst possible thing you can do ever, if you're using anything, is to get to a car. You have a 4,000, 5,000 pound missile that can do catastrophic damage to anyone you run into. And if you are in a state that you shouldn't be, don't. Do you understand?
Yes.
What's going to happen now? What are we doing?
I'm gonna continue with the drug program, with the drug court, and better my life and stop doing what I was been doing. And move forward from this.
Do you know what happens if you don't?
Yes,
What happens if you don't?
I'll go to prison. What?
You will go into a rehab facility. That's what's going to happen. I am now, and I've told Shreya that I don't agree with what's going on now. I do, but I don't, because what I really think is what the report said in that Safe P, which is an inpatient treatment facility. That's what I really think. But because she's so tenacious, I have agreed to try to let you do this on your own.
Appreciate that. Thank you.
If you are unable to do this on your own, we're going to do it the other way. And the other way is what the report says, and it is the treatment facility in the jail. It's going to happen one way or the other. Do you understand?
Yes.
So when you're out there, if you ever have a craving, if you ever have someone coming up to you, giving you peer pressure to go do this, don't. Find a sponsor, find someone else to talk to, call me, come here to court, call Shreya, but don't use. And don't hang out with the people that you were using with before. Do you understand?
Yes.
Can we give him a curfew so that he's not out in the middle of the night as part of the sober court?
I can add that, but they have their own special conditions, so I'm not sure. Let me see if they'll interfere.
Look, I don't want to interfere with their specifics. I mean,
Judge, we can just defer it to sober court since they are going to have the intensive weekly reviews.
I'm scared for you, Mr. Eli. I really hope that you can make this work, and I want you to do it. But, you know,
I am.
when you're using that kind of dope, don't go back to the old, don't hang out with who you were hanging out with. Don't go back to the places you were hanging out with, because all you need to do is be in that environment, and it's going to catch you up like this. If you start using, if you don't comply with these conditions, I will issue a warrant immediately. You understand? Mr. Eli, you're charged with, so we're going on the second, right? Everything else is being dismissed? Is that right?
Yes, Judge. The FSGI and false report is a dismissal.
What about, was there any restitution on the FSGI?
No, Your Honor, we weren't able to get in contact with the complaining witness.
It wasn't a major at all.
Okay.
Fender, like literally a bumper.
You're charged with 3 cases. You're charged with false report. You're charged with driving while intoxicated, second offense, and you're also...
It's the delicate dance of trust clashing with precedent. Do you lean toward the judge's caution, or believe the client deserves another shot? Then comes the gut punch. 2 DWI convictions already, and any misstep from here could escalate into a felony with years of prison time. The stakes aren't hypothetical, they're life-altering. And plea agreements often come with trade-offs just like this. Ask yourself, would you accept a deal knowing every move you make afterward will be under intense scrutiny?
Naturalization, you give up the right to appeal. Once you enter into this agreement, you are stuck with this until you complete it successfully, or unless we have to issue a warrant and file a motion to revoke. If you violate the terms, we will issue a warrant, put you in custody, and then we're going to have a hearing. And if they prove it to me, you're looking at an entire year in jail. You understand?
Yes.
How do you plead to driving while intoxicated, second offense? Guilty or not guilty? The other thing is this, is that you now are charged and will have 2 DWIs on your record. What happens the next time?
Prison.
Now, if you ever are in a car and you get charged, you will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand?
Yes.
I'm going to do everything in my power to prevent that from happening. Do not get into a car. I am suspending your license for 2 years. Do not get into the driver's seat of any car. Do you understand?
Yes.
So we're doing it. It's an 18-month probation, right?
Yes.
And then is it
DWI education
repeat offender, right?
and the DWI repeat offender.
So are we doing 2 DWI education classes?
1 DWI education and then 1 DWI repeat offender.
Okay. Victim impact panel?
It's not on there, but I can add it.
Well, no, I don't want to do anything that they don't want.
They have 60 hours of community service.
Yeah. So one of the things that you'll have to do is 60 hours of community service. I know that as part of a reward system that they have with you, the better you do, the more conditions they'll take off. So they may waive your community service time if you do well in the program. What else?
Your Honor, we looked into it and the code does say that you shall require 5 days, not less than 5 days, due to the 5 within 5.
3.
Oh, I apologize. What? Not less than 5 according to the code.
3 days.
According to the code?
72 hours is a condition of probation. Can we move over that?
Did you buy a second?
Yes, because it's outside the 5 years.
It's within 5 years.
It's the,
Mr. Lindsay, was it 5 as a condition or was it 3?
We went through 3, but we have counsel who are ready to come discuss.
I believe that the statute's worded a little strangely.
You don't say.
Just give me one moment, Judge. I just said it.
Why is it like this? I mean, I don't understand. Why just...
reads according to Article 42A, a judge granting community supervision shall require the condition of community supervision that the defendant submit to not less than 5 days of confinement of county jail, and if the defendant was punished under section 49.09A, which is the DWI second, and was subject to 49.09H, which is the 5 within 5. And that subsection H reads, the subsection applies to a person convicted of a second or a subsequent offense relating to the operating of a motor vehicle while intoxicated, committed within 5 years of the date on which the most recent preceding offense was convicted.
I don't have any information on the first one. When was the first
The
one?
first one was committed October 23rd, or conviction date was October 23rd, 2019, and the most recent that we're on now committed on May 5th, 2024.
So the other one was committed outside the 5 years.
Yes.
And this
Is it
conviction,
conviction or committed?
so my understanding is this is the conviction we're talking about. So he would be convicted of an offense under 49 with his prior being committed outside the 5-year window.
So so he committed the DWI out of county, I think it was January of 2019.
So outside 5 years.
And that's where the statute reads a little bit
Well,
confusing.
you were okay with the 3, right, Mr. Lindsay, right?
Yes, Judge, we're okay with the 3.
So we'll just do that.
Yes, Judge.
Probation.
Okay. Stay sober.
So are you doing?
Don't use. Mr. Eli, don't use. Do you understand? Don't go to any parties. Don't go to any bars. I want to also put on the bars, places of ill repute. Any place where it's 50% or more,
Judge, can
or
we
liquor.
release that or just whatever on the 3 days? He'll be released today, correct? According to today. Yes,
Okay.
there's nothing holding him, correct?
I don't think so. Is that?
I mean, no, once I get to the date.
Yes, perfect.
I'm in for those days.
Perfect.
Don't use. Okay? So how do you do the offense, guilty or not guilty? Guilty. We'll find you guilty, send it to the agreement, make it work.
There's 2 enhancements.
Is it true that you were convicted of the felony offense of possession of a controlled substance in 2020 out of the 209th District Court?
True.
Okay, true the enhancement. Okay, guys. Good luck, Mr. Eli. I hope it works. Thank you for being patient.
We'll do a Friday report at 6 p.m. on what? 2-3 weeks.
I'd say 30 days from now.
What?
He wants to do it 30 days from now on a Friday.
Okay, I'm okay with that.
Thank you.
Let's do.
I want him to report here, though. Hey, I want him to report here so I can take a drug test.
Okay.
So it'll be November 15th
Report to court 8 or 9 in the morning, and I'm going to take a drug test.
on November 15th.
On that date,
Yes. Don't use. Okay.
can I ask a question? Is that okay? So on November 15th, do I come here to?
Yes.
I want you to come right
Yeah.
here.
I'm saying just surrender here, right?
Correct.
Thank you.
Here in court with me.
Why can't you just go to?
Because I want a drug test.